Assalamualaikum warahmatullahi wabarakatuh. This is our Zoom recorded lecture for the topic strict liability. This is the topic after we have done with the topic res ipsa loquitur. This is actually just a short topic, but for the purpose of the lecture, I plan to divide our recorded lecture into two parts. Okay, so it's not going to be too long for you to listen to the lecture and watch the video. Okay, so basically, when we talk about strict liability, it falls under the rule of Rylance and Fletcher. So that is the case which established the rule. And the slides belong to Dr. Sony, and I have done some editing to it. Okay, for the outline of our lecture, basically, it covers three important parts. Okay, first, we are going to look at the definition, and then followed by the elements. There are three elements altogether. Okay, non-natural use of land, escape, reasonable foreseeability. And the second part of our lecture will cover defenses as well as the recent position of the rule. So what is strict liability? What is meant by the word or phrase here? So sometimes actually strict liability is called absolute liability. Strict means absolute, no conditions attached to it. Okay, liability which is imposed absolutely without any qualification or conditions. Or in other words, okay, liability, it refers to liability that does not depend on actual negligence or intent to harm. So there's no need to prove negligence neither negligence nor intention. No need to prove intention as well. The moment it happened, the moment it is being committed, then the third phaser, okay, the defendant will be liable absolutely. So in other words here, in the longer explanation, okay, it refers to absolute legal responsibility for an injury, for the damage, okay, that can be imposed on the wrongdoer without proof of carelessness or fault. So meaning that here, the wrongdoer can be liable, even though there's no element of carelessness, no elements of negligence, no fault on the part of the defendant. And actually, it also means legal responsibility for damages or injury, okay, even if the person found strictly liable was not at fault or negligence. So it's the same thing, okay, like the one that I explained just now. Okay, let's have a look at the case which established this particular liability. The case is Rylance and Fletcher, reported in 1868, a judgment by House of Law. What happened here? So we have two parties, defendant and complainant. So John Rylance, the defendant, he constructed a reservoir, okay, that's the picture, reservoir, on his rented land. Okay. So what's the purpose of having reservoir here? To supply water to his steam-powered textile mill. And the neighbor, okay, Thomas Fletcher, that's why we have Rylance Fletcher. So Thomas Fletcher, the complainant, he operated mines on nearby land, and in operating the mines, okay, he had tunneled up to all disused mines, which were under the land where Rylance Reservoir was located. So there was underground tunnel, okay? And then one day, defendants contractors, okay, did not properly block the shaft beneath, okay? And when filling the reservoir, the water escaped down the shaft because there's a shaft, there's a tunnel basically, all right, for the water to escape. And because of that, it flooded complainant's mines, okay? Because Fletcher had a mine. So the court held that defendant was liable even though he was not negligent. So there's no elements of negligence here. And in giving the judgment, this is the observation by the English Court of Exchequer. They said that, okay, the court said that, or the judges here, we think that the true law is that the person who, for his own purposes, brings on his own land and collects and keeps there anything likely to do mischief, if it escapes, must keep it at his peril. So this part of observation actually, it creates the element in which we can apply the rule of Rylance Fletcher or the rules of absolute or strict liability. And then it follows here, If he does not do so, okay, he is prima facie answerable, okay, for all the damage, which is the natural consequence of his escape. So starting from this case, there are also some other cases. That's why we come up with examples here, a list of examples. So other examples, other instances where plaintiff can sue for defendant for compensation under the same argument as that. The first one, okay, plaintiff whose grass or corn is eaten by defendants escaping cattle. Okay, cattle is the thing which escape. Or in other case, I mean, like in this case, Ryland's Fletcher, plaintiff whose mine is flooded by the water, okay, from his neighbor's reservoir. Or in another case, plaintiff whose habitation is made unhealthy by the fumes and vapors of his neighbor's alkali works. So the thing which escape here is alkali works. Okay, so what's the rationale, okay, behind the decision of Rylands and Fletcher? So basically, the victim in those incidents, okay, is damnified, okay, without any fault of his own. Mean that here, he is the one who caused damage, okay, so he's supposed to be responsible, even though he can say, oh, I'm not at fault, or it's not my negligence. And actually, it seems but reasonable, okay, and just that the neighbor, mean that here is in that particular situation, it seems fair and just, okay, to impose such a liability, so long all the requirements are fulfilled. So how do we know the elements and requirement? From the judgment of the case of Rylands and Fletcher. So in short, okay, he should be obliged, the defendant should be obliged to make good the damage which ensues, okay, which happens if he does not succeed in confining it to his own property. So whatever things he bring onto his property, which has the tendency to cause damage, okay, to the neighbors, to other people, okay, the moment it happened, then he has to be liable for that. Okay, we go to the elements. So this is element is basically we extracted from Rylands and Fletcher judgment. Okay, so there are three elements altogether and must prove all the three elements. The first one, non-natural use of land by the defendant. And the second one, escape of the thing that causes damage of plaintiff land. And the third requirement or the third element is the foreseeability of damage by defendant. Okay, for the first element is non-natural use of land. So here we want to know, okay, what's the meaning? What's the interpretation? What amounts to non-natural use of land? So we have few cases to discuss on the meaning or the interpretation of the word here. For example, in Pacific Tin Consolidated Corporation and Hoon, okay, the thing which, I mean, non-natural use of land, it relates to water. So the statement was put to users, okay, unsuitable and hazardous to their neighbor when it was made to hold water in great quantities instead of slimes. Okay, but in the case of Ang Hot Tai and Tan Sam Lee, we are going to discuss all the cases after this. Okay, in this case, the facts that the defendant have brought, okay, for their business, actually certain material, dangerous material, petrol and rubber. So it amounts to non-natural use of land. And in Ricketts and Lothian here, this is the rule or the ratio here. All right, it means it was explained here. Non-natural use must be some special use. Okay, non-natural means special, bringing with it increased danger. So because of the way you use your land, and then it increased danger, the risk, okay, to others. And it doesn't include the ordinary use of the land, okay, or such use as is proper for the general benefit of the community. So it's a balance. I mean, it's a balancing of interest here. I mean, you bring the defendant bring something onto his land for special use, okay, and it increase the risk. But then, what if it gives benefit to society and is just ordinary use of the land? So it won't satisfy this requirement, okay, non-natural use of land. Let's have a look at all cases. So Pacific Tin Consolidated Corporation and Hoon Wee Team. This is the appeal case. Appellant maintain on their lands large ponds for tin dredge mining operations. So they have some mining operations, mining works here. And for that purpose, they separated each ponds, okay, they have many ponds with bunds, okay, embankment, basically all the respective ponds. And the ponds here, the location, it was located above ground level. Okay, and water flow from one pond to another by means of spillway. So once the one pond is full, okay, with water, then it spill or it flow to another pond. And then still on part of location, the land was located in an inclined valley. So it's not a flat ground here, inclined valley. And a large bridge in the barn, okay, between two large ponds, which together house, so that's the quantity of the water, nearly 500 million gallons of water, a huge amount of water. So it caused a violent outflow to the lower lands, okay? And because of this, it caused extensive damage to life and property to the adjacent lands here, neighboring land. So when the court, the case was brought up to federal court, okay, and the court applied the rule in Rylance and Fletcher, and appellant was held liable, okay, because why? What's the finding here? The federal court found that, okay, it was unusual, okay, for tin mines in Malaya to have pools above ground level for retaining water. So if the pool is located on the flat surface, okay, and not above the ground level, then it is something which is usual, okay, ordinary use, okay, or ordinary operation of tin mine. But for this case, this is something which is unusual, okay, to retain a huge amount of water. So what's the normal practice, ordinary use here? The normal practice is to have mines holes below ground level, okay, to retain slimes or tins tailing. And Ong Hot Tai J, he stated here, okay, natural user of their property does not imply that miners had carte blanche, okay, here, complete freedom to carry on their mining operations in any manner, okay, even though it's considered something which is ordinary or natural, but it has to be done within, in a proper way, okay, cannot be in any manner. So consequently, the judge held that the use to which the sand bun was put in this case was non-natural user of land, and the bun was put to a non-natural use when it was made to hold water in great quantities instead of slum. So for other mining, okay, mining location, mining operation, actually this bun, okay, actually they were used to hold slimes, okay, instead of water. And what more, location is inclined valley above ground level, so it amount to something which is not natural, unusual. Okay, we have another two cases here. We have the case of Renal Link, KL Sinamberhad, and Datuk Dr. Harnam Singh. And we also have Ang Hock Tai and Tan Samli. Okay, for Renal Link, KL's number here, Renal Link ran a hemodialysis center, okay, and the center was held liable under the rule, okay, of Rylance Fletcher. Why? Because there was escape of gases into plaintiff premises because defendant used formalin and ranolin, okay, in operating the hemodialysis center. So because of the usage of this chemical, okay, formalin and ranolin here, it produced noxious gases, okay, that escape into plaintiff clinic. And the clinic is located downstairs, okay, one floor below the defendant's clinic or premise here. So because of that, plaintiff suffered discomfort, sickness, and injury. So it fulfilled the element of the non-natural use of land and also escape that we're going to discuss later. For Ang Hock Tai and Tan Samli, defendant carried on business of tire repairers and tire dealers, and they need petrol, okay? They kept petrol for their business, and they need to mix petrol with rubber and gum. And the premise is that plaintiff live on the upper floor of the defendant's premises. So the business was done at the lower floor, okay? Upper floor, it was rented out. And one day, fire broke out at the premise for unknown cause. They don't know why the fire broke out, okay? It caused 3 explosions because of the petrol here, okay, and all the materials, followed by a burst of flame that quickly destroyed the whole premises. And sadly, okay, plaintiff wife and son died. So very tragic incidents here, okay? And back to Dr. Harnam Singh just now, the case, right? At the High Court level, this is the judgment, okay, by the judge Rahmah Hussain. This is the relevant part of the judgment. Okay, it is stated here, okay, the judge was satisfied from the evidence, okay, produced by the plaintiff that he had proved all the ingredients, okay. He proved the first element, okay, there was formalin, okay, stored in the premises, and then because of that, okay, noxious gases were produced, and the said gases escaped into plaintiff premises. So obviously, we can apply the rule of violence and fracture in this case. And in Ong Hat Tai, this is the relevant part of the judgment by the judge, the name is Patros J here. The court held that the defendants have brought upon premises in which they are in de facto possession. Actually, they own the premise, okay? So they have the power, they have the authority to bring whatever materials, okay, onto their premises for the purpose of their business, okay. Obviously those materials are dangerous and it's not something which is natural. Okay, they are under an obligation to keep those materials under control so as not to cause mischief to their neighbors and what more, because they rented out the premise, okay, to the tenants, okay, the upstairs, okay. So they have to make sure everything was safe, but it wasn't safe. That's why the fire broke out. So we are done with the first element. Actually, all the cases here will satisfy all the elements, but we just focus on the relevant part. I mean, the highlights of the case. If we were to include all the elements, yes, it satisfies all the elements for all the cases that we are discussing. Okay, second element is escape of the thing. So first, no natural use of land, and then the thing must escape. Okay, for example, in the case of Reed and John Lyons and Company Limited, 1947, appeal case, appellant worked in the respondent's ammunition factory and he suffered injury when a shell, okay, that's the picture of the shell that was being manufactured, exploded, okay. And he brought the claim under rules of violence and fracture, but it wasn't successful. Why? Because there had been no escape of the thing that inflicted the injury. So it was contained within that particular location, locality, okay. So to succeed under violence and fracture, there must be an escape from the place where defendant has occupation or control to a place outside his occupation or control. We also have a local case of Woon Tan Kan and Asian Rare Earths in Berhad, 1992, is pertaining to dangerous radioactive gases. Yeah, so this is the Woon Tan Kan. So who was the plaintiff? Plaintiff was the residents of Bukit Merah. So these residents, many of them, okay, a group of them, they sued the defendants. They're asking for injunction to restrain the company. The name of the company is ARE, okay? Asian Rare Earth, ARE, from operating, alleging that the activities from the factory produce dangerous radioactive gases harmful to the residents of Bukit Merah. And they based their claim on violence and fracture, but the claim based on violence and fracture was not successful. Because why? The way to do it is that the resident must have suffered damage. Okay, but in that case, they have yet to suffer damage, but there's a risk, okay, of the damage, but no actual damage suffered yet. Okay. But the court allowed the plaintiff to get a quiet time injunction, temporary injunction, okay, which is exception to the above rule, which requires damage here, because in order for the court to allow quiet time injunction here, no actual damage need to be proved. But to succeed in violence fracture, there must be damage suffered, okay, to the plaintiff. Then only the claim will be allowed by the court. Okay, the third element, forcibility of damage, and this is the landmark case, common law case. The case is Cambridge Water Company and Eastern Counties Leather, Public Limited Company, Public Limited Company, 1994. What happened here? Complainant, they extract water to supply to the public, and then they discovered that the water was contaminated, okay, with a solvent. This is a liquid substance. And then actually later it was discovered that, okay, the solvent came from a factory, yeah, Eastern Counties Leather Tannery, and the location is that it was located 1.3 miles from the borehole, from the source of the water. So now complainant claim on negligence, okay, nuisance as well as rules and violence and fracture. So they base their claim under 3 cause of action. First on negligence, okay, and nuisance and rules in violence and fracture. So for violence and fracture, the third element is not fulfilled. I mean, because why? Defendant cannot foresee, okay, the damage suffered by complainant, so cannot claim, cannot succeed under violence and fracture. So they really have to prove their case under negligence or under nuisance, but not under rollers and fracture. Maybe the first two elements were fulfilled, but not the third element. Cannot foresee. Okay? That the such a liquid, okay, would travel up to the water source, borehole. Okay? And what more, we cannot foresee. Such thing happen. It never happened before. Okay, we stop here. This is the first part of the lecture. So I'm going to continue with the second part later. So I stop share for a while. Okay. Assalamualaikum warahmatullahi wabarakatuh. Bye for now.